And we are getting started, and it's my pleasure to introduce you all to the Liquid Legal folks, who will be telling us about their Oath of Justicia student Oath of Justicia student competition. We have our former CodeX fellow and co-founder and board member of Liquid Legal, Bernhard Waltel, with us. We have Elijah Granite from the University of Bayreuth with us, and Winona Horton. And so we're curious to learn about the competition and the projects that participated. And so yeah, Winona is one of the participants of the prize-winning team, the Gavel Smashers. So really excited to have you all with us here today. And before I turn it over, just wanted to encourage anyone in the group who has any important updates for the group, or any asks or any news to share, to do so either now by speaking up now quickly, or by using the chat function. And any takers, any news? Okay, Scott is sharing some information in the chat about the World University that he started, and okay, thanks for that update, Scott. And all right, if there's no additional updates, I wanted to turn it over maybe to Bernhard first.
Hey, Roland.
Are you there?
Yeah, I'm
fantastic.
Here.
All right, Bernhard, over to you.
Thank you very much, Roland. It's good to be back, at least virtually. Thanks for inviting us to present on the Liquid Legal Institute, and also on a specific project on the Oath of Justicia, something we did in the working group on education. But Elijah and Winona will later on report. Before we jump into the Oath of Justicia, I just wanted to give a brief update and introduce the Liquid Legal Institute to the community here. My name is Bernhard. I'm sitting here in Munich, dialing in. It's quite late, but it's a great pleasure to present the Liquid Legal Institute to you. Feel free to ask any questions if you have. And if I'm just showing, I do not have slides, but I will show the web page. So everyone is cordially invited to join me on the web page. It's liquid-legal-institute.com. So you'll find all the information there. But for the next 15 to 20 minutes, I want to give you a brief introduction into what is the Liquid Legal Institute about, who are we, how are we working, and what is our mission, basically. The Liquid Legal Institute, it is an association. It was co-founded 4 years ago in 2017. Actually, this was the time when I was still at Stanford. This is something we did remotely. We were sitting together, and we were thinking about, so how can we foster legal innovation in a very broad sense? We were observing the legal tech market closely, and we've seen a lot of different companies and startups arising. And we thought ourselves, or we identified the need for a platform where people, like experts, can meet, can discuss, and really can push things forward. And this is how we raised the idea of creating a neutral platform, and the idea of the Liquid Legal Institute was born. We constantly get the question, why Liquid Legal? What does this name actually mean? And the name roots back to the first main publication that was edited by our co-founders, so Kai, Dirk, Roger, and others. And they describe, or the authors in this book describe, the transformation of legal, the business of law, basically, into what they call here the subtitle, a business-savvy, information-enabled, and performance-driven industry. So you see, these are terms. This is a mindset. Which is relatively new, or which was relatively new back then. I think nowadays it is common sense, but at the time back then, the authors really describe a visionary thinking, a way of thinking about legal. Meanwhile, we published a second volume of the Liquid Legal book towards a common legal platform. I will just come back to this topic later on, because the common legal platform is really what brings all the different projects and all the working groups together. Let's focus on the web page. Yeah, so for those of you who are online in parallel, feel free to browse around, and I will tell you a little bit about the homepage is structured and what you find there. So on the main page, you'll find basic information about our mission, what do we care about, basically what I just explained to you orally, but you also get an overview of the basic structure that we at the Liquid Legal Institute have. So we do have 5+1 working groups, and within each of those working groups, projects are performed. And the working groups, you see them here, they are digitalization, they are standardization, the methodologies, education, and material law. And by the way, on the working group on education, you will hear Elijah and Winona reporting on the outcome of a specific project, namely the Oath of Justicia. And the 5+1 working group is then the common legal platform, because we believe, or we are convinced, that the legal innovation is not something happening isolated in fields within legal, but it all needs to come together. And this is what we call the common legal platform. It also has a more technical notion on a research grant that we received from Gaia X, European Cloud Initiative. Don't have the time, unfortunately, to report on that, but this is a project we will work on the next 3 years. And we received a very well, we are well funded for this project. So for the different working groups, you find more information also on the web page. If you go on the working groups tab, you see there is a lot of information. This is basically what we try to spread also to the world outside. Let me put it that way, because we want to be as transparent as possible. So we believe in things like open source and knowledge sharing, information sharing, because we think that we all lack of information, and those in the legal field. We need to work on those fields together that can be tackled in a collaborative manner. And then obviously the question arises who we are, so who is engaging in the Liquid Legal Institute. And I want to briefly jump on our members page, because we do know we have several different membership options. We do have corporate members, either a small and mid-sized enterprise or a large company. And you have the logos here on our webpage. Those are huge companies, for example, like Novartis, but also law firms like Osborne Clarke, Reusch Law, Luther, Deloitte Legal, and also big companies like Berger Ingelheim, and so forth. But of course, we live from the humans. We live from those who are contributing, and you see, and then just scrolling over all the different people that joined meanwhile. So as I said, we have more than 400 different members. Only a small portion of those are listed here in the member section. So every member is cordially invited to present him or herself. And at this point, I wanted to highlight that the Liquid Legal Institute was caring about diversity and cross-functionality and interdisciplinarity from the beginning on. Why was that? Because we realized from all the publications, from all the projects and everything that we had in terms of conversations, that the future of law, or the future of legal, is not only shaped and implemented by lawyers, but it is really a large variety of people with different mindsets, with different perspectives that needs to come together such that this thing like legal innovation can happen. Let's get us back to the working groups again and focus more on specific projects, because you might say, well, okay, but what are you specifically working about, and how does this really feels like if you work on a project? So you see an overview of all the projects that we started here on this webpage. The projects, by the way, are proposed by the members. So every member has the possibility to propose a project by him or herself. The Liquid Legal Institute provides the platform on which these projects are executed. We give advice, we bring people together, We create sparring partners, but we also find project sponsors. We support with project management. And as we are working 100% with Microsoft Teams, so every member gets his or her access to our platform, you are immediately able to collaborate, to connect with other members. So this is something we're very proud of and which is very well perceived by our members. One project is close to my heart. As you might know, I did my PhD in natural language processing, and this was also one of the topics why I was visiting Roland and the folks from CodeX. I was working on legal text analytics. And I was always suffering. So we at NLP, or if we start with NLP topics, we always start from scratch. So we hardly ever know what is state of the art when it comes to legal text analytics. And this was one of the motivations why we set up a project at the Liquid Legal Institute. We do have a very active natural language processing community, for example. And we said, hey, what if we all sit down and all combine our knowledge and all our information and create a GitHub repository that is freely available to each and everyone out there. So there are no paywalls, there are no password barriers and so forth, and start collecting every resource that is publicly available when it comes up to legal text analytics. We have a collection here. It is constantly growing. Everyone is cordially invited to contribute. And this is very well perceived. We also got good feedback from the AI and law community in general. We got a lot of companies that joined or that are interested in this kind of thing. And it was very a specific example of the outcome. So everyone who is interested in something like that, or in creating, kickstarting something like that, where it's about joining forces on a specific project, this could be like a blueprint almost. But there are also many other projects. We are not limited to data science or this very narrow sense of legal tech projects. We also have projects like lawyer well-being. This is also a great project that we are driving in the Central European space. I know it is much more advanced in the US market and also in UK, but as you can imagine, in Europe, I think in good old Europe, the clock is ticking a little bit more slowly than it is in it does in other places. And lawyer well-being is not so commonly discussed within the legal field, or it's not only perceived to be tackled within the field of legal innovation. We have we did a survey with very interesting findings, publicly available again on our webpage, and there's much more to come. We are having strategic partnerships with large organizations here in Europe where we want to tackle this topic on lawyer well-being, not only in a descriptive point of view, so what is going wrong or where does the pressure arise, what are the main problems, but also how to prevent or what measures can be taken in order to avoid or to like this mental disorders and this huge stress and anxieties that lawyers are facing, also due to digital transformation topics. Very briefly, and I'm well aware that I do not, or I simply can't cover all the different topics. I want to speak about the Common Legal Platform. So the Common Legal Platform, as I said at the beginning, this is one of the main visions that we at the Liquid Legal Institute share. We dream basically about a platform that has like no barriers in terms of interfaces and in terms of interoperability. So we do see the legal field is becoming very, let's say, heterogeneous when it comes up to the implementation of legal tech solutions, but also when it comes up to the implementation of processes, because many different applications create their own standards, they create their own processes, and there always lack of interoperability. So we want to, together with our partners, create what we call the Common Legal Platform, such that all these different applications, all these different legal tech solutions work seamlessly together. Of course, each and every system is focused on its specific specialization. There will be applications on natural language processing. There will be others on document generation. There will be others on I don't know, process outsourcing, for example. But these platforms, they can seamlessly work together. And this is what we would describe as a common legal platform. How this could be implemented, we have launched a dedicated web page, which is a subpage of our Liquid Legal page. It's common-legal-platform.org. You can find our approach by the guiding principles that we have. Everything is available on GitHub. You can also comment on that. Feel free to give feedback. We are really looking forward to hear your thoughts on that. You see also from a technical perspective, how can this be realized? How can a common legal platform be realized? There are different layers that need to be inspected and need to be brought together, from technology to data over application up to the utilization layer. And you also find a brief insight into the platform benefits that we do see once a common legal platform is installed. As said, the Federal Ministry of Economy here in Germany, they granted us with a funding for the next 3 years. It's a little bit, it's still tentative because, as you might know, we do have federal elections and there aren't those kind of huge decisions taken before elections. So we need to wait a little longer, but we are very optimistic that we get this funding. And just to give you a glimpse of an idea, we have been selected among 16 winning projects. And among those 16 projects, the total budget of almost 200 million euros will be spent. So this should be a decent amount of money to create first pilots and to really bring this common legal platform into life. Finally, there's also the My LLI section. So what it briefly summarizes how to find your way into the Liquid Legal Institute. There's the huge claim, meet us at MS Teams. Every one of us is online there. We are very well connected. What you find or what you get from once joined the Liquid Legal Institute, you will find a community that is interdisciplinary. Everyone is, of course, cordially welcome. Bring in your expertise, join the network, make the network stronger, join ongoing discussions or start a discussion by yourself. Maybe even sooner or later start a project by yourself. We are happy to guide you through, also with our experienced PMOs. We are optimistic and we always looking forward to create new results. And we also, so we at the Liquid Legal Institute, we also support in creating results and also spreading then novel ideas, be it either on publications or on advertising, and then bringing new people on board. And I think this is a very well, let's say, ramp that we now built for the project that is now presented by Elijah, or the outcome is presented by Elijah, which is a project that we did within the working group of education. So where do we have it? Here it is, the Oath of Justicia. It was a competition that we started beginning of this year. We invited students to submit their ideas or to think about how could an Oath of Justicia, in analogy to the Oath of Hippocrates, which is very well known in healthcare, how could this Oath of Justicia look like? So what would be like the main idea? What would be the guiding principles a lawyer should consider in the 21st century with all the challenges he or she is facing? And we thought, why should we ask legal experts if we can also ask students? Because we think, or we thought, they have fresh and novel ideas. And we have been very lucky that so many participated. We had participations around the globe, and it was very difficult actually to select the winners, as each of them really had great ideas. But yeah, at the end, you always have to make a decision. And we were lucky that we had a very strong jury, also interdisciplinary. And now we are very proud that also the CodeX group gives us the opportunity to present those results by those who created them. And I don't know whether there have been questions in the chat or somewhere else. If not, I would hand over to Elijah.
Quick question, Bernhard.
Sure.
There's also, so I saw one of the things you are active in is standardization. Is there something you can share about that? Well, what are you trying to standardize?
Yeah, so standardization has many different layers, as we all know. We have one dedicated working group because we think that it is important when we speak about legal innovation and we want to make, let's say, platforms and systems interoperable, that we have common standards that can be shared. And in the working group standardization, there are projects going on that standardize, for example, document types like NDAs or SPAs, so legal documents, and they think about why or what could be standardized, what is common, what is shared, and then decrease the barrier when it comes up to negotiation or when it comes up to the exchange of these kind of documents. So this is roughly summarizing what we are tackling in standardization. But you can see also if you click on standardization. So these are the two projects that are currently going on: standardization of share purchase agreement and standardization of NDAs. You find more information there.
Thank you. Actually, yeah. Okay. Thank you, Bernhard. Thanks for that great overview. It's a really interesting organization, and there's a lot of cool things going on in Liquid Legal, and excited to learn about the competition that you guys ran. I just have to tell you, so we're having the full hour today for this presentation. So we're going until 2:30. Personally, unfortunately, I have to dial out or leave the meeting at 2:15. So I have to take my son to a doctor's appointment. But Susan will close at 2:30, or you guys can sort of close at 2:30. It's just my apologies in advance. But great, well, cool. So looking forward to hearing from Elijah and Winona.
Okay, hello everyone. My name is Elijah Granite, and I am really delighted to be here today, and I will just jump right in with my presentation then.
Cool.
And everyone can see this. It seems to be up. Excellent. All right, so we are presenting our submission for the Oath of Justicia. By we, I mean myself, Elijah Granite, but also my colleagues, Lissy and Sasha, who worked with me together on this project. And so I'll jump in and talk about the people. This was a really modern collaboration in as much as we were never at any point in the same country, all three of us. But we came across the project, thought it was really interesting, thought it was adjacent to different parts of our research. I'll introduce. So Lissy, she is from England. She is an incoming pupil barrister at a commercial chambers. She has background in law. She worked in the Ministry of Justice. And at the time we did this competition and entered into it, was finishing up her studies as a barrister at the Inns of Court College of Advocacy in London. Then they have Alexandra, Alex or Sasha de Friends. She is a lecturer, researcher, and doctoral candidate at Universität Bayreuth in Germany. She is admitted to the Czech bar and has advised all over Europe on sort of a lot of different legal and policy issues, and is generally very knowledgeable. Then there's me. I'm the token American in the group, originally from California, where in fact I'm giving this presentation remotely from right now, but did my legal studies in England, where I met Lissy at law school, then started my doctoral studies at Bayreuth, where I met Sasha, and will shortly be going back to London to finish qualifying as a barrister in England and Wales, where I will end up working actually at the same place as Lissy, although we did not plan it this way, with the consequence that I'm doing about 4 things at once. So we all came at this with sort of different backgrounds and different perspectives. And we then now had this challenge of designing a Hippocratic oath for lawyers. And when we looked at Hippocratic and we read many different oaths in preparation, we wanted to focus on the idea of the Hippocratic injunction, the Hippocratic mandate, which is to always see the patient first, to always primum non nocere, to always do no harm first, to always, in some versions of Hippocratic oaths, see the patient as nothing but a fellow creature in need of help. And so that was our idea of Hippocratic, but then we had the idea of, well, how do you add to that? Because of course, as any lawyers watching this will know, essentially, and we tried to look at every jurisdiction we could get our hands on a practice guide for, every lawyer in the world takes some sort of oath when they're admitted to their bar. In some cases, I know in some US states, like Michigan comes to mind, I think in certain bars in Brazil, you actually, as part of the oath, make ethical commitments with regards to your clients or frivolous litigation. And so there is already those commitments. And of course, regardless of the sort of oath you take, every lawyer in the world already has ethical obligations from either regulatory bodies, like in the US, a state bar, or a sort of local or regional bar in many parts of Europe, and then also, of course, any legal obligations. And these sort of long-standing institutions for regulating how lawyers act do very well with sort of the traditional problems of legal ethics, the sort of things you'd see in a legal ethics class. They actually have very little on new problems. And when you look at codes of conduct for lawyers, there's sort of vague stuff now about social media or online, but there hasn't been that much to catch up with technology. So we decided we wanted to create a supplementary oath, something that would add value, and something that would complement the existing obligations lawyers have. And we thought that our competitive advantage in creating this was our nimbleness. We could work faster, our diversity, our willingness to be flexible, and our sort of trans-jurisdictional perspective. And that perspective in particular was important because what we had to avoid, and you'll see here, by the way, this XKCD cartoon, but essentially in designing any new standard, it is, of course, always essential that you don't just create another competing standard. And that's why we always focused on being supplementary rather than in competition with any existing ethical codes. But we, of course, had the problem that we wanted to create an oath for every lawyer. But of course, there are completely different ways lawyers work. So even within common law jurisdictions, the way a barrister in England and Wales has obligations both to their professional and lay client is completely different than the way an attorney has obligations in the United States. And meanwhile, of course, then you have civil law systems where, for example, there might not be legal professional privilege for an in-house counsel, whereas, of course, there is in common law systems. And more broadly, we wanted something that a lawyer in China or Benin or Saudi Arabia could use. And the truth is, most lawyers in the world work in places where democracy and the rule of law don't operate as smoothly as they do in the countries many of the people who write about legal ethics come from. So what we wanted to do is always focus on the individual lawyer, because no matter what the system around you is, you as an individual lawyer can always do your best. And again, we relied on our diversity here to say, okay, well, Sasha, you come from a civil law system. Does anything we're saying not make sense? Or does anything we're saying not quite work in any given system? Then there is a linguistic challenge. We want this to be universal, and that means it cannot have specific terms. So it can't say attorney or barrister or firm or chambers. It has to be broad enough that it can be ported to any jurisdiction in the world. And we wanted it to be specifically amenable to translation, because as much as we might like to hope as Americans, sometimes the world does not live and breathe in English only. And so we worked off the language that's used in the International Bar Association guidelines. So for example, their guidelines on the taking of evidence in international arbitration. And those are sort of model documents for how law can be easily translated. But equally, we wanted to make sure that this was all accessible to lay people. Because to paraphrase a famous saying by the Lord Chief Justice of England, as was at the time Lord Hewitt, ethics must not only be done, but must be seen to be done. So now we come on to what we wrote. And what I'm going to do is in the time and trying to be conscious of it, walk through what we created. We started off with the preamble, which you'll notice with the terms in brackets is designed to be flexible. So maybe instead of in the name of justice, you might put the basmala. You might not say I swear, you might say affirm. But what I really want to highlight here is the savings clause, where you say without prejudice to my existing obligations. And that was really important to put in here for the very simple reason that we never wanted someone in a disciplinary hearing to go, no, the reason I broke Code of Conduct Rule 2-1 was because I took this other Code of Conduct that said otherwise. So never. This oath is only supplementary. It can never be a norm which overrules the existing norms beneath the oath. So we start with the first section of the oath, and that is, of course, the client, which is at the core of what we do. And now the first point about data protection was prompted by the realization that, and this is something people who have done transatlantic work will know, data protection varies enormously between jurisdictions, especially between the European Union and places that don't have equivalents. And also data protection is something that increasingly is becoming an obligation, something people look for insurance for, something that's just a compliance headache. And we wanted to say no. Data protection is an affirmative obligation that no matter what the rules are around you, you are always actively looking for new technology to make sure that whatever you do, you are putting the security of your client's data as maximally protected. And we want is that this is your client's data is as secure as in the old days when you might have the escrow account in a safe in your office. And that comes to section 2, which is we wanted to ensure that we are using design thinking, we are using the new insights into behavioral science to make sure that every time you are making sure that your client's comprehension is put first. And we put a very important word in there, which is the word equal, the equal level of service. And that is because we want to ensure that as lawyers increasingly have clients who are in person and clients who are virtual, that there is a complete parity of service between those two. And this brings us to the last point, which is about how technology is changing. And anyone who has followed the developments in technology and looked at the sort of increasing proliferation of startups have noticed that the world is becoming more bespoke. Everything is tailored individually to you, down to, and this is research I know that colleagues of mine at Bayreuth are looking into, personalized food and nutrition. And the same should be true for law, so that as technology improves, we want lawyers to be maximizing their client's experience. And that must mean personalizing the client's experience, using the power of technology and data to accomplish something that was simply impossible before because of the human labor involved. So now we come on to the second point, which is how the lawyer stands vis-a-vis herself and society. And this point in point 1 is something that those who know EU law will recognize. It is the idea that algorithms and AI are excellent tools, but they are never decision makers. Decisions must be made by a human and using human principles. And this is an important affirmative obligation because you cannot fulfill the Hippocratic injunction, primo non nocere, first do no harm, unless you first ensure that you are safeguarding who is doing things towards your client. And AI must be under supervision and decisions must be human with the human principles of ethics. And this is not, of course, anti-technology. We wouldn't be working with the LLI and our friends and colleagues here at Stanford. We didn't love technology and think it is fantastic for law. But it is saying technology is our friend and our partner, but we never allow it to supplant the human principles that led to the society that produced that technology. As part of ensuring those human principles are continually developed, we come to point 2, which is the legal profession is not an island. We are always working with the public, with lay people, but also with other professions, with accounting, with medicine, with engineering, to improve societal well-being. And that is, the legal profession must recognize we are not just, to use a term from legal ethics, hired guns. Of course, we are, in fact, actors and citizens in a global community made possible, of course, by technology that has allowed us from all over the world to be here at this meeting. So then we come to point 3, which is conduct. And most lawyers will be subject to some conduct rule. by now that says that they must not embarrass the legal profession, but we wanted an affirmative obligation, which is that you must always, when you conduct yourself online, elevate the public's esteem for the law and its practitioners. You must not simply be avoiding the negative, but actually seeking to accentuate the positive. I mean, that's a powerful, actually, heuristic for when you're deciding what to post or not to post, what to say or not to say, that you must always be actually, with everything you do online, going, how does this raise the esteem for law and its practitioners? So finally, we turn to the obligation individual lawyers have towards their fellow professionals. And one of those is that much like any other field where you are reading the journals, keeping abreast of developments, you should be actively seeking out new things. And we wanted to move beyond the old sort of, and this varies by state and jurisdiction, what it's called, but in England, it's called CPD, continuing professional development, where you show up to the seminar, you log on, you get the points. And we wanted an affirmative obligation that actually you are actively looking for new things and looking to innovate to make justice better. Because a lawyer has to be actually working for these things. You must be, to quote I believe the Bible, you must pursue justice, not just sort of let it go. And that brings us to point 2, which is sharing insights. And this is a classic thing, of course, in technology with open source work, with bug bounties, with sharing vulnerabilities and white hat hacking. And we see this as something that must be imported to the profession, which is except where, of course, you are obligated by either legal professional privilege or by order of a court, you should be sharing insights. And I think the days when every lawyer had their little special form contracts and their little clauses that they would carry around with them and use whenever they were assigned something are over. We have to share. We have to have platforms like the LLI where we are exchanging ideas. And part of that exchange, as we get to point 3, is that you must have diverse professional contacts. So engaging with the legal profession is no longer going to the club and seeing a lot of people who look like yourself. It's actually ensuring that you are working with lawyers in, say, Kenya or Mozambique, or even firms that deal in completely different things. You're a commercial firm, you should be working with people who do criminal law or immigration law, because it's only by actively working to have diverse professional contacts. And this is something made possible by technology, by platforms like Curiosity or LinkedIn more generally, that you can more easily make diverse contacts. And then we come to the conclusion. We thought at the end, you might say fiat justicia. And I think this is just worth noting that it's important. Lots of professions have various services. Doctors have white coat ceremonies. In America, there's the Order of the Coif, or I think I'm a part of Phi Beta Kappa. There's in Canada, the Order of the Engineer. There's something valuable about having professions inculcating these ideas from actually the scholarly stage, rather than just once you've qualified, you take an oath. So I think developing ceremonies and traditions around this could be a fun and actually really powerful way of getting at that human need to be part of something greater that has that sense of tradition. So that concludes talking about the oath. I'm now going to also talk about the ancillary competition, part of the competition, which we, the team of which I was a part, also won, which is the deployment plan, which is how do we get the oath out there and engage with it? And so I'll do this briefly to be conscious of time, but part of this deployment plan is this conference. So congratulations, you have all helped deploy the oath, because it is ultimately taking it and engaging with the community. Traditional oaths were sort of decreed either by statute or by a bar association. We reject that. There's a metaphor, those who in software development might know from, I believe, Eric S. Raymond, of in software development, you have the cathedral and there's one big plan and it's decreed from on high, or you have the bazaar where you're running around the markets, you're haggling, you're exchanging, you're developing. And we want the bazaar. We want something that is part of the sort of, to go off Lawrence Lessig, free culture, like in Creative Commons. We want the community to exchange it, take it. Nothing be happier than if people, quote unquote, steal because it's yours to take this text of the oath and change it, remix it. We hopefully eventually want to get some sort of Git style tracking and input for decision makings. We like the idea of non-hierarchical liquid democracy. or as some have called it, sort of adhocracy, the antithesis of bureaucracy. And one of the things I want to note about is for the global element, because that is so important to our team. We think that this has to be global, because despite, I think, that the tendency in law to sort of silo in our own jurisdictions, because obviously necessitated by the fact of separate jurisdictions, lawyers separate themselves, it has to be global. And so we like the idea of Facebook-style community translations that in sort of each nation or language, we could have sort of chapters like the Wikimedia Foundation. But we also want to actively solicitate input from non-lawyers, from community stakeholders, from actors in other areas. And I'll just leave it at this. The oath right now, what we submitted and what we were privileged enough to have be the winning part, is in the alpha stages. And it is something that we would like to beta test. And I think, especially as Lucy and I move into legal practice, we'll be testing in practice. And then we'll eventually get to release, but it's always evolving. It will never be finished, because this oath is all about enduring affirmative commitments. And ultimately, an oath that is about enduring affirmative commitments in response to new developments must always be continually developed going forward. So that's our deployment idea. That is our oath. I am happy to take any questions at the appropriate time, but I believe actually now at this point in the presentation, we are going to give over to Winona, if I recall the order.
Yes, that's correct. I just can't quite turn my video on at the moment. If maybe Roland could give me a hand with that. Thank you. Brilliant.
We can see you. There you are.
There I am.
Hey.
Thank you very much. And thank you so much, Elijah. That was a fantastic presentation. Noting the time, I will try and keep this to 8-ish minutes so that we have time for questions at the end. So just bear with me one moment while I share my slides. There we go. Can everyone see those okay? Okay, brilliant.
Yes,
thank
very
you.
good.
So I'll just go through our submission very briefly. Elijah covered a lot of great points already in terms of the role of technology and the importance of diversity. So I'll begin just running through a quick agenda of what I hope to cover in the next little while. So we'd like to introduce you to the other members of the team. So despite the one that I'm the only one talking, it was a group effort. Our motivations for taking part in the competition, our process of researching and constructing the oath, and then a little bit of a deep dive into the different sections of our submission. So I'll start with myself. My name is Winona. I'm currently attending the University of Melbourne and completed my undergraduate studies in 2019, and I'm currently a candidate for the Juris Doctor, set to graduate mid next year. I work across criminal and family law and have a bit of experience in the not-for-profit sector as well. You can see a picture of me here in 2019 before I stopped seeing the sun for 2 years. I think we all know why, but that's what I used to look like back when I got vitamin D. This is another one of my colleagues or peers, Matt Harper. He also completed his undergraduate in 2019, receiving his BA in History and Criminology. He's also in his second year of the Juris Doctor, has been heavily involved in improving the student experience through his work with the Graduate Student Association. Matt's also in this call alongside Angela, another University of Melbourne student. You can guess how we all met. Angela completed her undergraduate studies in July this year, holding a Bachelor of Arts in Economics, Politics and International Studies, as well as a Diploma of Languages in German. She's looking to join us in the Juris Doctor next year. We haven't quite scared her off yet, and currently works as a research associate at a public policy think tank and runs her own startup in relation to financial literacy for young women, which is a great project. And I would all suggest you look up VIDA, V-I-D-A, which is Angela's project. Enough spruiking aside, we initially signed up for the competition because it seemed like a new and fun way to consider the role of ethics in the profession, and also coming from Australia, it offered a meaningful way to connect with the international legal community. So when reading the pitch, I guess, for the competition, the first thought that came to us was, well, why an oath? What is the purpose of an oath above like Elijah pointed out, another set of conduct rules. And we thought it was really important as a separate document to align personal values with those of the broader professional community to help bridge the gap when, for example, duties might be in competition with one another. So we wanted our oath to be flexible enough that it wasn't so specific that it wouldn't be applicable in 10 years, but also still able to address current and future tensions within the profession. While that also wanting to maintain a careful balance between ethics, professionalism, and rapid technological advancement. So we wanted to kind of play a delicate balance of being specific enough that it would be useful and able to be followed, but not so specific that it would date itself like a MySpace reference in a film from about 10 years ago. So in structuring our research, we can broadly put it under 3 umbrellas of past, present, and future. So I focused on the past, namely the Hippocratic element to the oath and how it would draw into the historical roots, I guess, of the legal profession. Matt wanted to look at current conduct rules and ethical principles for lawyers in a few different jurisdictions to maintain profession's integrity and independence, while Angela really focused on the technological advances in the industry, as well as how to uphold the rule of law, administration of, and access to justice in the context of technological advancements that we are seeing. So diving a little bit deeper into the past element of our research, we really wanted to acknowledge and pay respect to the foundations of the legal tradition. We felt in terms of making this oath, there had to be some kind of, I guess, incentive for people to want to really buy into it and feel like it was a valuable thing to do. So we found that if we try and invest it in some really foundational ethics and foundational principles that most, or at least a variety of legal practitioners would already be familiar with, it would be much more likely to resonate and be able to have a more robust quality to it. We also felt very strongly that the ethics needed to go beyond simple rules. So like, for example, the conduct rules that are already in effect in many different jurisdictions, but it also had to act as a directive and create a binding moral imperative. So we really tried to use quite strong language and very clear language to get across those messages. For example, we drew from the repetition of "I will" in the Hippocratic Oath in our own version. Our research into the past also was reflected in the structure of our oath. So we represented each of the 5 sections or 5 canons of rhetoric through the 5 sections of our oath. I won't attempt to pronounce the Latin versions, but they were invention, arrangement, style, memory, and delivery. So invention related to the method and delivery of argument, and that's where we kind of attempted to encapsulate the fundamental ethics that we wanted included in the oath. Arrangement more so focused on selection, organization of arguments, and it was there that we captured the duties to the court. So namely, making sure that the duty of a lawyer was paramount to the administration of justice, which we found was a commonality across jurisdictions. Then we've got style, which related to the style of discourse, and making sure that lawyers communicated in a way that was clear, complete, and appropriate, particularly with clients, making sure that there was no crossing of boundaries there. Memory, we looked at, and traditionally, obviously memory meant the memorization of what you were going to say, which is much less of an issue now in the time of technology. So we vested in that instead the role of the lawyer as a member of the community, and then finally delivery and context. And that's where we put a lot of our technological ethics, I should say, in how we deliver information to clients within the legal profession. Moving on to Matt's research, he looked a lot at the different systems of legal regulation throughout the world and looked to incorporate common principles to reflect the cosmopolitan and international character of the modern legal profession, which Elijah has already spoken a lot to. So I won't go into in too much depth, just noting here a few of the different threads that we were able to pull from our own jurisdiction, so the Australian jurisdiction, where we have a uniform law for all professionals, as well as the American Bar Association and the European legal profession. You can see this quote here: "Against a backdrop of rapid technological change, we recognize that digital inclusion and access to algorithmic justice remain among the most significant challenges inhibiting widespread access to legal services, particularly for clients with child backgrounds, the elderly, or those with a disability." So this idea of digital inclusion and access to algorithmic justice really drew our focus and our intention to make sure that advances in technology, although very promising, make sure they don't leave anyone behind. And this is something that Angela looked into in a lot of depth. So in the past few years, especially in Australia, we've seen a plethora of low-cost, easily accessible tools that have helped really narrow the knowledge gap between legal experts and clients, which we've seen broadly as a positive in helping people know their rights, know what they're entitled to before the law, and feel empowered to seek legal advice when that's appropriate. However, there's the risk of literacy barriers, not just English language literacy barriers, but also literacy in relation to how to use technology, which is then compounded by unintended breakdowns in legal services. So an example of this from our own jurisdiction was the robo-debt scheme that was run by the federal government over the past, I'd say, almost a decade now, which resulted in almost 500,000 incorrect debt recovery letters being sent out to welfare recipients. So it's just making sure that these issues of people that are already struggling to get fair and equitable access is not compounded then by breakdowns in AI learned systems. So on that note, while we are optimistic about the benefits that technology can have, we're also want to make sure that it's an ongoing process to improve the accuracy, safety, and accessibility of innovation in the legal sector. So our final point that we ended on was technology remains an effective tool that can make justice more accessible and efficient, but with the asterisk that very careful attention needs to be made to make sure that that efficiency is not brought on at the expense, I suppose, of those in our society that can least afford it. So noting the time, I will not go through our oath in any detail, but it is available on the Liquid Legal Institute's website. And I believe there's now time for questions for Bernard, Elijah, and myself.
Great. So fantastic work, everybody. I mean, I'm just blown away. So thank you for really impressive presentations and important work. And I would also like to ask all our presenters to drop your emails into the chat in case people want to follow up with you afterwards. So I will go ahead and get Elijah up on video here. So I'm going to multitask. All righty, so we have a bit of time for questions, so we could maybe hang on a little longer, although I imagine some people drop off. So let's open it up while the presenters are dropping their emails into the chat and see if people want to either unmute themselves or drop the questions into the chat. Looks like maybe we will have a thread going here. So let's see. So I think I'll just kick it off. I did have a question for Elijah. I noticed on section, and not to nitpick, but this was just something that I thought was super interesting about the presentation. On section 3.1 on the profession, I noticed that there was some language in there that said, make use of any tool that came along. So I thought, not a lawyer, but I was looking at that and I thought that seemed kind of broad. So I was just wondering, maybe you could talk about the thinking there about making it so inclusive like any tool, and whether you considered whether there may be pressure from, say, vendors or people on the service provider side, were this to be broadly implemented as an oath to, maybe open the door to maybe some undue pressure in that regard. But anyway, some of the thinking I thought might be interesting to hear.
Yeah, it is a very good point. And anyone who reads the legal press will know that every vendor is certain that their new tool is the single greatest thing in the history of law and will revolutionize. And very often it's an Excel spreadsheet with some extra things attached. But I think the issue is that lawyers tend to see legal tools and usefulness as, oh, it will be this new database, and they go, oh, Westlaw is a new tool and it will be like that. And the problem with that attitude and innovation is the next thing might not look like the old thing. I'm sure there are better technical terms for that, but I'm in law, not technology. But innovation is often zigzags and jumps and to the side. It's why anyone who watches older films will always note with delight how wrong any predictions about the future are. And so what we want by that sort of any tool is to say, it's not just using what seems to us right now to be the next thing of NLP and AI. It's using the thing that we don't know. We can't predict when we write this oath. And that was kind of the idea is at some point you have to accept innovation makes fools of us all, but then how do you work with that to better the profession?
Thank you. Yeah, I think there was a comment here that someone, Whitaker Thompson, put a comment, so I'll allow people to read that in the interest of time, maybe good response. And we'll go ahead and take the question from Bethany, has her hand raised. Bethany, if you want to go ahead.
Yes, hello, and thank you for your presentation. This is for both Elijah and Winona. I think, Susan, you might have already partially asked this question a bit, but you mentioned that you plan for the oath to evolve as time moves forward. And as both law and legal technology changes across the globe, how do you expect or predict the oath to change with it in the coming years? And do you have any plans for widespread sharing or distribution with lawyers or future lawyers?
Yeah, I'll just give a brief answer. So we talked about this a bit in the deployment plan. I think one of the biggest things that will change is that, frankly, a lot more people will become interested. I think as technology and law tech, and I know it's always dangerous to say we're on the edge of the law tech revolution because everyone always says that, but I really do think we are. And I think as those technological changes happen, there's going to be suddenly a huge uptick of interest. And I think what we're trying to do now with the LOI and the oath is to say, like, we're there just in time because we're there before the wave crashes over. And I think what we will see is actually divergence. So it will start off uniform, but one of the things that's great about a liquid and flexible thing is the challenges of the legal profession are completely different. So if you're in Kenya and you have great mobile phone connection, but no wired internet, and a lot of your technology is taking leaps in ways we didn't see, you might have different issues. So what we would expect is for everyone to take it and make it their own. This is not sort of in any way to be like imperialist or to decree it. It's take this thing, this starting point, and make what you need for your profession.
Yeah, I'll just make a very brief follow-up because I think Elijah really hit the nail on the head there. That in our deployment plan and part of our vision of it was it wouldn't just start at the professional level, but start, in our institutions, in our academic bodies, so that it would be coming up as something that was as natural as, client confidentiality. It would just be something that, you learned or was associated with the profession at the earliest stages before you even get to the point of practicing. So it wouldn't be something that you'd have to additionally learn later on, but it would be rooted in some of the core principles of what you do from day one.
And maybe also to add from an LI perspective, so from the meter level, I think it's so important to have like this working group education and also projects and initiatives like that are on the, in a way that innovation happens. We also think about these kind of concepts and notions, and also code of conduct. So I think this is at least equally important as always think about software and technology and how to make a new business model. So very happy to have these contributions here.
Thank you.
Yeah, thank you. I actually, in reading Whitaker's comment, it does sound like a question. So I'll just kind of throw this out there and see who wants to take it on, or maybe several of you may. A good argument can be made that US law is already too complex and each state has its own rules of professional conduct. So do individual courts and voluntary bar associations. Many of these rules impose affirmative duties on lawyers, for example, to safeguard clients' information or to stay competent with technology. Also, there is an ever-growing body of case law about what lawyers should do and not do. To what extent do you think that adding another rule to this system, we might even broaden that to international systems as well, kind of suffer from this patchwork approach, can actually deprecate these rules' meaning and be counterproductive? How could your oath counter this unfortunate trend?
Maybe
Yeah,
I can start with Elijah, go first, please. No.
I completely agree with the point on complexity in law. It certainly applies abroad. Lord Justice Hedden Cave actually gave a very good lecture on this in English law at Gresham College recently. And it certainly applies with professional discipline. I remember when I was doing mini pupillage in law school on a professional discipline case, and it was a case involving potential misconduct by a solicitor in England and Wales, and just walking in and seeing wall to wall of filled binders of evidence and professional rules and changed professional rules. So I agree. And you never want to add to the complexity. And there was that XKCD criterion in my presentation. You never want to be the extra standard. However, I think the advantage we have here in both our submissions is actually to a large extent the simplicity. This is not something that is meant to be litigated, something that is meant to be turned into, with no offense to my chosen profession, lawyer nonsense. It is actually meant to be something that is useful for the individual lawyer in helping them go about what to do. And I think that's a distinction here, is this oath is not meant to be used in evidence against you. This oath is meant to be something that helps you be a better lawyer and make society and your clients better off.
Absolutely. And also from my perspective, again, I think the oath is really an opportunity to face this complexity, because if you read between the line, it's arguing towards listen to your inner moral compass and also develop it in a altruistic, for a better society sense.
Yeah, just to echo what Bernard and Elijah have said, the way we envisioned our oath and the way we wrote it was that it would be not so much an additional, for every whole profession it needs to be covered, but more so something that the individual can take and carry with them in carrying out their duties within their own jurisdiction. So again, it's not an addition, but really a cushion to fall back on when the rest of it all gets a bit confusing. You can drill back into, okay, what are my core obligations here? What does it mean to me to be a lawyer? And really refer back to that when navigating what often comes up, which is competing duties and difficult decisions.
Great. Well, great answers, everybody. And thank you again for a really impressive presentation and important work. So with that, we'll go ahead and wrap up for today. Next week, we're going to take a little breather, and so we'll be back at the end of the month. So we'll watch your email, and we'll see everybody back then. So thanks again.
Thank you. Thanks for inviting us. Bye-bye.
Sure. Take care.